Welcome back to Everything LA Real Estate. I'm your host, Mike Babakhanyan. So today I have a special guest for you, Sevan Gurginian, attorney at law. Sevan, tell our viewers a little bit about yourself.
Sure. Thank you very much. My name is Sevan. As Mike mentioned, I'm an attorney here in Glendale. A little bit about myself. I'm a father of two. That's why I have bags underneath my eyes. I don't sleep. I also live in Tahunga, so I'm a local attorney here.
Very good.
I focus primarily on bankruptcy and trusts.
Well, speaking of trust, I got a lot of great questions, but
Sure.
you guys just started a new service about homesteads, right? First, tell our viewers, what is a homestead?
Sure. So this is a new service that I started, and I think it's really important because the question always comes up, either with my bankruptcy clients or my trust clients.
Okay.
I need to protect my house. How do I protect my house from judgments? Okay. So the answer is by filing a homestead declaration on the property. So a homestead declaration is a document that's prepared and you record it with the county on your primary residence.
Okay.
So the key is you only get one homestead, okay? So you can only do it on your primary residence. It does not apply to rental property, doesn't apply to investment property. But at least you get to protect your home from most judgments, which I'll get to which ones don't apply.
Okay, fair enough. So the homestead protects the homeowner's property, correct? Okay, so what's the maximum amount of equity could be protected by this homestead?
That's a good question. So the minimum is $300,000,
Okay.
but right now it's up to $700,000, and that's based on the median sales income of that county. So in LA County, it's about $700,000. In other counties, it could be a little different, but it's generally over $500,000 or $600,000 right now.
Got it, got it. Can the homestead protect against federal tax liens or child support obligations?
Great question. So it protects only against certain judgments, but not including tax liens,
Okay.
liens for unpaid child or spousal support, and it also doesn't protect against your own loan or the mortgage company against your house. So if you don't pay your mortgage, the homestead declaration does not stop the home from being foreclosed.
Foreclosed on.
But if, for example, American Express or you get in a, God forbid, car accident, they sue you, they get a money judgment for, let's say, credit card debt,
Okay.
and it's recorded against the property, they can foreclose on the property if they enforce that judgment lien. But the homestead declaration will prevent them from doing it because you can protect up to $700,000. So conceptually what it means is if the judgment creditor forces the sale, the escrow company has to give the homeowner the first $700,000.
Oh.
So the judgment creditor is not going to go and foreclose, so they're just going to wait. So, and the judgment is good for minimum 10 years up to 20, but typically 10 years.
10 years.
So as long as you don't sell or refinance in 10 years, you're fine. And the other trick is the homestead declaration must be recorded before the judgment creditor records their judgment lien.
Makes sense.
So we call it the race to the courthouse, okay? But we don't go to the courthouse, it's a race to the county recorder. So it's always good just to file it and you'll have a peace of mind. And you only have to record it once.
Once, okay. So what if I decide to sell my house and buy another property? Do I record it again
Yes.
or does it transfer?
No, it does not transfer. That's a great question. Another one of the disclosures I have when you apply for one is you have to remember to reapply that homestead to your new property. Because if you put it on the property you have and then you move, you have to file another homestead on the current property you have. So it doesn't transfer.
Got it. So if our viewers are interested in applying for a homestead, how do they go about doing it? Do you guys offer that service?
Yes. So it's a new service that I just started. It's something I've been working on for a very long time, and it's on our website. So
Okay.
my website will be, in this video somewhere.
On the bottom somewhere.
At the bottom somewhere. So if you go to my website, it takes literally just 10 seconds. All I need is your name and your property address, and it's a one-time fee of $300, which includes our time and the recording and notary fee. You also get to schedule your own notary in our office. You come in, and in less than 5 minutes, you'll have your document. We take care of the recording for you. So, and you'll have a peace of mind. So if you go to my website, you'll have it ready very, very quickly.
That's a great service you guys offer.
Thank you.
So I got a few follow-up questions for you, Sevan. Can joint homeowners file the homestead declaration together, or does each individual need to file it separately?
It's much better if each individual records their own homestead. So in a scenario where it's husband and wife, only one of them can do it. But if they're not, husband and wife, they're joint tenants, siblings, each of them should do their own.
Okay.
And the other thing to keep in mind about the homestead is on that document, it says what is your nature of your interest in the property.
Sure.
So where you got to be careful is if the property is your separate property, you got it before the marriage. On the homestead declaration, if you say this is community property with my wife, well, now you're kind of admitting this is community property. And again, God forbid you guys get a divorce, your ex-spouse is going to say, remember on the homestead, you said it's community property?
Give me my share.
You got to be careful on that language. So there are services that provide this, but just make sure, that it's spelled out that it's separate property, community property.
Very good point. What would you say some of the misconceptions are out there about homesteads?
Sure. The misconception is which properties qualify for this.
Okay.
So the properties that qualify is your home. Okay. So a lot of clients will tell me, can I just apply for 5 homestead declarations recorded against 5 homes? And when the time comes, I'll choose which property is going to be my home. No, because if someone wants to challenge it and say you're just playing games,
Sure.
Then all 5 of them will be stricken off. So you gotta all of them.
Interesting.
So
Okay.
you don't want to play games. So it doesn't apply to rental property.
Okay.
Now, if you have a house that's a rental property and you just happen to move, I'm going to move to my rental property. Well, just make sure to then apply for the homestead on the rental at that time. So take it off your primary, move it on to the rental, if that is actually going to be where your home is.
My last question regarding homestead is, how would a homestead declaration protect someone in bankruptcy?
Okay, great question. So the main question I always get when people contact me for a bankruptcy is, I don't want to lose my home. Okay. So in a bankruptcy, the homestead declaration is automatic, meaning you do get a homestead protection. You can keep one home.
Okay.
The only little caveat in a bankruptcy is if you bought the house less than 3.5 years ago, the amount of equity you can protect is actually less than $200,000.
Why though?
Because the bankruptcy code does not want people buying a house, within 3 years, not paying their debts. So they're like, we can't let you benefit from having a $1 million property, which is probably a studio in Glendale or something, and then filing a bankruptcy to rid your debt. So usually I'll look at the title to my client's property. If it's less than 3.5 years, sometimes they don't have that much equity. They put 5% down, so they don't have that much equity. But that's just a way around it. But we take care of the bankruptcy clients and make sure their home is protected.
Good to know. Good to know. Well, why don't we switch gears and talk about living trusts? Okay. Sure. I hear this all the time. Mike, I have a will. I'm protected. Why do I need to have a living trust? Because I always recommend to my clients, hey, is your home in a trust? If not, call Sevon.
Right.
But sometimes they say, I have a will, Mike, I'm protected. So talk to those viewers out there that have a will and they feel like they're protected.
Okay. So I want you to think about this scenario, and then I'm going to come back to your question.
Okay.
If something were to happen to someone, I'll choose me. Okay. So let's say I have a property under my name.
Sure.
I have a bank account at Capital One under my name. Let's say, God forbid, something happens to me and I take the long dirt nap. Okay. How is my wife going to go and access my bank account? Like, conceptually speaking, when you go to Capital One, they're going to say, like, who are you? Where's Sevon? Well,
I have a will though.
But she says, I have a will. It doesn't matter. Exactly. Your name is not on the account. So we can't give you his $800,000. I don't have $800,000. But including the house, like if she's like, hey, my spouse passed away, I need to go sell the property. They look at the title, well, where is he? So I want you to keep that in mind, is how do you access people's properties when they're no longer around? Now, to go back to your main question, what if you have a will? Well, what if I write a will saying, if anything happens to me, everything goes to my wife, which is actually, this is kind of off topic. The shortest will, this is a story I heard.
Okay.
The shortest will ever was from Thomas Jefferson.
Interesting.
Where he wrote in 1 page, 3 words, all to wife. That's all he did. And then he signed it. So, anyway,
all to wife.
That's all he says, all to wife. So now going back to the question, if I have a will, and then my wife takes the will saying, look, he gave it to me.
Sure.
A will does not have power to transfer title or give you access to bank accounts. Okay. You would need to take that will, go to the probate court, spend a lot of money and time in probate court because the probate judge needs to approve that will.
Correct.
Because what if you signed it? What if someone forged my signature? You know, what if I wanted to give it to, you know, some charity? So you want to avoid that situation. So if you only have a will, it still needs to go to probate court.
Tell the viewers, how long does the probate court process take? Because they think it's quick. It's not.
Yeah. Probate court process is, and I say this respectfully for everyone involved in the probate process, is the probate process we have in America is one of the biggest scams we have in America. And I don't say that, you know, lightly. And the reason I say that is the mechanism to transfer property to next of kin has been so complicated that the people that benefit are the attorneys, okay? They charge a lot of time, and there's a long process for you, I would say minimum a year. You're going to be involved in probate court process. You want to avoid going to probate, okay? Because everyone you owe money to. So if I die, all my credit card companies, if I used Medi-Cal, they're all going to show up to probate court, and the probate judge will not allow my wife or my kids to get my house without paying off all my debts. Avoid probate court. And the way you do it is not by a will, it's by using a trust document.
Okay, so let's talk about trust documents. I know your office prepares living trusts.
Right.
What does it cost on average?
So if you go to my website, the total fee for the whole estate plan, which includes the trust, the will, the medical directive, and the power of attorney forms, and if you have minors, it also includes the guardianship documents. All 5 documents are $1,800, which includes one property. If you have additional rental property, it's $400. If you have a business to add, it's $200 per business. So, and you know,
that's a great price. I've heard attorneys charge $5,000-$6,000 just to prepare it.
So most other attorneys will charge more. The question I get asked is, why is mine cheaper? Well, the process we have in my office is very streamlined. I've spent a lot of years and time, including the Homestead Declaration things I was talking about. I've spent a lot of time preparing the Homestead Declaration process to make sure I cut down on my cost, which saves the customer a lot of money. So the reason why it's, you know, I don't want to say cheaper in my office, we have less, our fees are more reasonable, is because the process we have to do it is also been streamlined in my office, so we don't spend a lot of, you know, waste time, etc. So
what's the average process, like timeline? Does it take a month?
No, it's we can have your documents ready in about 72 hours. Wow. So, and it's all done quickly. We just send you an email, you fill out 16 questions, which takes about 5 minutes. And, you know, clients will ask me, do you need to bank account number, my dollar amount? No, I don't need to know your bank account number. I don't need to know the dollar amount. That's none of my business. So all I need is your photo IDs. That's it. You fill out 16 questions and your photo ID. In about 72 hours, you'll have your entire estate plan documents ready. You can schedule yourself and pick a time that's convenient to you. You'll come to our office in Glendale, sign, notarize, and we take care of all the notary fees, recording fees as well.
I've always been curious, how does estate planning work with digital assets like cryptocurrency?
That's a great question. So when we're talking about digital assets or even assets involving like a bank account, so think about the trust as having a box. Okay. So imagine there's this imaginary box in front of me. The goal is to get everything inside this box. So the property has to go inside this box. To get bank accounts inside this box, you just have to go to the bank and you tell them, I created a trust called the Babakhanyan Trust. I want this bank account in there. The bank does that for you. And the way you know the bank did it is because on the next time you log in on your app or your checking account online, it's going to say your trust name on top. So that's how you get stuff inside it. When we're talking about digital assets, if the cryptocurrency platform, for example, allows you to switch that account in there, that's how you can do it. If it doesn't allow you, which I know certain platforms do not allow you to do it, it has to be in your name.
Correct.
The easiest way to do that is inside your trust documents, you just say, all my cryptocurrency goes to my kids. Just make sure you write your login for your cryptocurrency inside your trust documents. It's that simple. And certain wallets have, I think it's the 16-word password or something. So I always tell my clients, make sure you write that in there so your beneficiaries know how to access your crypto.
Sevan, what are, in your opinion, some common mistakes you see people making when they're trying to create their estate plan?
Sure, great question. I would say a couple of the mistakes I see is the most simple and straightforward, not putting anything inside your trust, okay? So think about a trust, as I said, like a box or a suitcase. Why would you get a suitcase if you're not going to put clothes in there? Okay, so same idea. Why would you create a trust if you're not going to put your stuff in there? So the most common mistakes I see is people not actually transferring properties into the trust. When they go to, I'm not going to name other non-attorney services, they actually don't help you transfer the property. They help create the trust. They say, here's your trust, but they don't actually help you transfer the property into the trust. So that is very important. When you buy a new property, I explain to my clients how they're going to put their new properties in there, which is as simple as telling the escrow officer, put this title directly inside our trust. So that's the most common thing. They don't switch the bank accounts in there or add beneficiaries. And also, similar to life insurance, they don't add the trust as a backup.
Okay.
So let's
Life
say
insurance.
for life insurance, so let's say, God forbid, like I have life insurance, which is an incredible product. I highly encourage my clients to have it.
Absolutely.
So for my life insurance, I have my wife and my kids as the beneficiaries. What if, God forbid, my wife and I pass away at the same time? My kids are still minors, okay? So the life insurance company is, for example, going to hold on to the check and say, well, who do we give this to? Who's next in line? They're not going to cut a check to a minor. But if you list the trust as a backup beneficiary, they will give it to the successor trustee to hold for the kids. So it's those kinds of little mistakes where, legally speaking, it's called funding the trust. Just make sure you put your stuff inside that box. Otherwise, why do you have it?
Yeah, that's a great point.
Yeah.
Especially about the life insurance.
Right. So, and then also, this topic actually came up where, in your field about properties and refinancing, when loan officers are refinancing a loan, the bank is not going to lend to property held in a trust. So what they will do is they're going to transfer it out of the trust, put it in Mike Babakhanyan's name, give you the loan. But I've seen so many times where they don't put the thing back inside the trust. The loan officer says, hey, my job is done. So I've gone back and checked from my clients. I'm like, hey, do you remember the refinance you did? They actually didn't put it back in there. Put it back quickly. So those are some common mistakes.
I heard you say you go back and review your client's trust. I think that's a great service. How often do you guys go back and review your client's trust? Is it annual? Is it like every couple of years?
Yeah, there is no set timeline. I usually will send an email out sporadically, I would say every 6 months, just to touch base. But I just want the clients to always know, and I give them a sheet on how to do it themselves, because sometimes they don't want to come back to me, which, my goal is to make sure it's so easy. Going back to the streamline process, it's so easy that I explain how they can do it moving forward.
Correct.
How to update it, how to add things to it, etc.
So I have a very important question. Okay. How could someone select the right executor for their trust? Because it's an emotional thing, but you want to make sure you select the right person that can handle things when you pass.
Right. So I always tell people, if your kids are over 18, you would name your kids as the executors and the successor trustees themselves. Most of the clients will say, can all 3 of my kids be co-trustees? There's a way, the answer is yes, they can be co-trustees, but I always advise them to implement a procedure where, what if they don't get along? What if you have 3 kids, 2 of them say, we want to sell it, 1 of them says, no, let's keep it. So we implement a procedure in there, with basically a voting system. 2 out of the 3 wins, we're going to sell the property. So I always tell clients, choose the one that you trust the most. So which kid do you think is the most reasonable? And as your life goes on, one of those kids doesn't become responsible. They're engaged in, God forbid, gambling, drugs, and things like that. That's when you update the trust to remove that kid from power.
What if, let's just say, my kids, I don't have that much confidence in them. They're still young. I don't know what type of an adult they're going to grow up to be. How would I choose the right person? Is it my best friend? Is it my parents? Is it my siblings? And what's your recommendation?
So again, it's going back to who the person feels confident and are they going to follow your wishes? Are they going to do things in the best interest of your kids? Or are they going to take the money and go to Vegas and blow it? Okay. So most of the time people will select their siblings. So including myself, we selected not all my siblings, the ones that we trust. But if people don't want to select family members, I've had situations, they're like, we don't want my sisters involved, my brothers. There are independent trustees that actually do this. So there's a firm here called the Pice Montgomery That's all they do. They're basically third-party fiduciaries
Mm-hmm.
that you can name in there. So they step in and they will administer the trust for the best interest of your
Because
kids.
it gets, it's emotional time for the family member,
Correct.
so that makes sense. So how could a living trust help family members avoid disputes after someone passes?
Okay, so the best thing about a trust
Mm-hmm.
is first of all to avoid probate. Number two, to put you in control. Okay,
Mm-hmm.
so this is my house. That's my money.
Mm-hmm.
I get to dictate what happens to it. If I want to give it all to, some charity, that's up to me. Okay. So the way you avoid the dispute is you clarify inside the trust documents what you want to happen. Where the disputes arise
Okay.
is, in my experience, it's very innocent. Okay. I've had situations where clients tell me, I usually ask them, how many kids do you have? "Oh, I got 3 kids. Okay. Then I read the questionnaire they completed, and I noticed that only 2 kids are listed as the beneficiaries. I'm like, gosh, this is strange. So when I meet with them, I said, what about your 3rd kid?
Mm-hmm.
And it's an innocent omission, but they tell me, look, we already bought this kid a house. We already, he or she is taken care of. These 2 are still at home. They don't have anything. So in case something happens, we want them to get this property. So again, to avoid family conflicts, I say, look, I understand and that makes sense. We just clarify it inside the documents, because when you pass away, the people that have a right to those trust documents are your direct heirs, which are your kids, and anyone you listed as a beneficiary. So if I list the church as a beneficiary, my successor trustee, you got to give them a copy. So if one of your kids that you omitted looks at it and says, oh my God, why did mom and dad leave me out? That creates conflict. But if you write in there, the reason we did this is because we already gave you a house during our lifetime. That's called the advanced inheritance. So then they kind of understand.
Get
So
along.
yeah, so that avoids conflict. The other source of conflict, which you want to avoid, is what do you want to do with your property? Sometimes we tell them, do you want to leave it to your kids? Let them decide, but everything is going to be equal. If you rent, share rent equally. Sell, share equally. What if one of the kids says, this is mom and dad's house. I'm going to stay in here. I want to live here, And the other kids are like, okay, that's fine, but we kind of want our money, like, what do we do? So we put language in there that they have to, whoever wants to live in there, you have to go get a loan on the property and you buy out the other siblings. So sometimes they call it a buyout beneficiary loans. Okay, so it's a straightforward, it's a hard money loan. So which is good for 1 year. You buy out your siblings and you get to stay there. So the
That
conflict
gives you time to refinance.
right.
later.
Give time to refinance, you pay off your siblings, and the house is yours. So if you don't have that kind of, safeguards in place, what's going to happen is one of the kids is going to live there. And I actually had someone this happened to. They live there, but they're not going to pay the mortgage. They're like, I'm not going to pay the mortgage. I'm not paying property taxes. The other siblings that don't live there are like, well, if you don't pay it, we're going to lose mom and dad's house. Well, tell me where it says I have to pay it. So the other sibling that doesn't live there is paying for the mortgage and property taxes, because who wants to lose this property?
Yeah.
So if you don't put that kind of safeguards, you're going to have conflict.
So, Seven, I have a trust. How often do you recommend that I review my trust?
Good question. So I also get clients saying, can you review my mom and dad's trust? It's from 20 years ago. When you should update it is, in my opinion, when your kids become over 18 or over 21. Okay. So if you have minor children, if there's nothing to change, just leave it alone. But just keep in mind, who do you have in place as the successor trustee? Yours could be your sibling Jack. Okay. But what if you and Jack get in a fight? You're like, I don't want Jack involved in this. So that's a time where, even though your kids are still minors, you want to update it to remove Jack. Sorry, Jack, if you're watching.
Sorry, Jack, you're out.
So that's a scenario that happens. The other time where you want to update it is, what if your kids are older? Let's say your kids are, 25, 28, and
They get married.
they get married, but let's say, God forbid, one of them goes down the wrong path in life with drugs, alcohol, and gambling, and just a lot of debt. You're like, wait a minute. If I pass away, one of my kids who's down the wrong path in life is about to get $1 million inheritance, and they're going to blow it.
Yeah.
So that's one time where you want to update it. If your kid is on the wrong path, and the simple way you do it, it's a one-page amendment. You put the power in the good kid's hands, and you say, support your sibling, let's say $5,000 a month, When they clean up their life, you have the power to then give them the inheritance. So that's one way to protect it.
Thank you, Sewang. You shared a lot of great nuggets with us. I hope you viewers found a lot of value. I sure did. If they want to contact you directly, what's your phone number?
Sure. My number is 818-928-4445. You're welcome to go to my website, which I did myself using Wix, at gorginyanlaw.com. You'll see everything you need on there. So you'll see all the pricing is on there. How to get your Homestead Declaration is on there. So we have your documents ready in about 72 hours. And my office is in Glendale.
Perfect.
So
Appreciate your time, my man.
my pleasure.
Thank you so much.
Thank you.
Talk to you guys later.